So, good day, everyone. Today, we'll continue our discussion on obligations of partners to third persons. And now we'll be discussing about 1819, another very long provision. But basically, we would break this down by paragraph again and for examples as well. Before moving on, I'd like you to take note of following important terms. One is yung sinasabi pong title, at saka another is conveyance, and another is equitable interests. Just for knowledge of everyone, kasi baka if we move along, ay hindi po natin makukuha yung mga discussion. So kapag sinasabi nating title, basically it's a legal evidence of a person's ownership rights in a property. So it is an instrument such as a deed that constitutes such evidence. So, ibig sabihin ng title, ordinarily sa atin po ay yung pong titulo kapag yun po ay lupa, ano ba yung nag-represent ng ownership mo sa lupa, di ba titulo yon? So, it might be an OCT or TCT, ano po. So, yun po yung instrument na evidentiary right na nag-represent ng ownership mo doon sa property. Kapag sinasabi namang equitable interest, that's an interest held by virtue of an equitable title or claim lang talaga on equitable grounds, such as the interests held by a trust's beneficiary. So, merong ika nga ay trustor-trustee relationship. Parang iniwan lang po yung property, pinaubaya sa iyo na i-manage lang ang property. Pero wala po talagang nata-transfer na ownership. Just an equitable interest or claim lang on the property because you are holding it as a trust for the, holding it in trust for the beneficiary. So, here, under 1819 po, ang sinasabi lang po, at saka conveyance. Ano ba yung conveyance at saka ano yung deed of conveyance? Ang conveyance pala po, yun yung sinasabi namin transfers, transfers ng pagko-convey ng property. So, pareho lang yon. And then, yung mga deed of conveyance or document na nagta-transfer ng property such as a deed of sale, deed of donation, kung yun po ay mana, ay po pwedeng extrajudicial settlement of the estate. So, yun po yung mga deed of conveyances na naglilipat po ng property. So, under 1819, it tells us that real property po pwede siyang i-register or it could be owned in the name of the partnership, all of the partners, and po pwedeng sa isa lang or some or not all of the partners. So pili lang kung A, B, C, D yan, pwede lang kay A or kay A at B lang. Pero hindi din sa lahat. It could be as well one or some or not all of the partners in trusts for the partnership. So it's either for A lang but it is actually in trusts for the partnership. So ang true beneficiary is really the partnership. Or it could be named or registered or owned in the name of a third person, but in trust again for the partnership. Here, that is why I'm emphasizing equitable interests. So yun po yung mga instances of which real property may be registered into whose name or into whose kanino po siya po pwedeng ipangalan. And then, under 1819, sinasabi sa paragraph 1 ay, where the title to real property is in the partnership name, nakapangalan siya sa partnership name. Any partner actually, kung nakapangalan yan sa partnership name, any partner may convey title to such property by a conveyance executed in the partnership name. So kahit kanino po sa mga partner could transfer title to such property kung yan po. And then the document should be in the name of the partnership kasi in the first place, the partnership is the property is in the name of the partnership. And kami din I'm involved in land transfer. So, it's common lagi na lagi pong titingnan natin na tugma po yung mga deed of conveyance with all other na mga documents representing ownership. Kasi if there would be deviation, there should be an explanation to that, or it should create doubt. Baka naman hindi niya talaga ownership yun. Kasi let's say, for example, the tax declaration, which is an indication of ownership, could be named to some other person. Yes.
Mommy, I got a friend over.
How many?
2 of them.
Who?
Alexa, Angela.
Alexa and Angela. Okay, later on I'll check your friends. Okay, I'll have classes first. Okay.
Okay.
Did you eat ice cream?
Yeah.
Okay, you close the door, please.
Okay, goodbye, Mama.
Goodbye. Ay, grabe ang pinto. So the first one is, as what I've mentioned nga, going back, okay? So if the case would be where the title of the property is in the name of the partnership, so ABCD partnership, any of the partner, that would be A, B, and C, pwede niya i-convey ang titles to such property by a conveyance or document executed in the name of the partnership. So bali kung through sale yan, dapat ang seller ay C, partnership name. But the partnership may recover such property unless the partners acts bind the partnership under the provisions of the first paragraph of 1818, which is yung apparently not in the usual way and the usual way, or unless such property has conveyed by the grantee or the person claiming through such grantee to a holder for value without the knowledge of the partner, that the partner in making the conveyance has exceeded the authority. So let's break this down. Anyway, paragraph 1 talks about yung real property registered in the name of the partnership. Ano? Ang document daw dapat executed in the partnership name. So as an example, A, B, C, and D are partners of the firm E company. A, a parcel of land registered under the name a parcel of land was registered under the name of the partnership, ECO. And then was sold by A on behalf of the name of the company, which is a clear illustration of paragraph 1. Pero without express authority, so under 1818, take note, the purchaser now is X. Does X ba become the owner of the property? Ordinarily, yes. Pero pwede daw makuha ng partnership ang land unless the firm is engaged in buying and selling of land. So kung usual way yan, hindi na po pwede. Pero kapag hindi naman po yan usual way, then it's an authorized act. Tama po ba? Under 1818. Ano? And let's now go for paragraph 2. So paragraph 2 basically tells us paano daw kapag ang property is registered in the name of the partnership. Then dapat po ang conveyance being executed by a partner in his own name passes the equitable interest of the partnership, provided the act is one within the authority of the partner under the provisions of the first paragraph of Article 1818. Para mas maintindihan po natin, let's have an example. Under paragraph 2, A, B, C, and D are partners of the firm E company, which is engaged in buying and selling of land. So usual way nila ay buying and selling of land. A parcel of land now is registered in the name of E company, which is registered in the partnership name, which was sold by A in his own name. Nakapangalan ang document or conveyance document to A, pero nakarehistro ang property to the partnership. Does the buyer become the owner of the land? If not, what right does the buyer have? Well, here, the answer to that is that the buyer does not become the owner of the land. Kita nyo, hindi siya tugma, di ba? Nakapangalan siya sa partnership, pero ang deed of conveyance ay nakapangalan po kay A, yung document po, ano po, kung yun ay sale, di nakapangalan po kay ang deed of sale ang seller ay si A. So however, he gets the equitable interest, so nandito na naman ang equitable interest claim, kumbaga, of the firm insofar as the land is concerned because after all, the selling of the land is the usual way or course of business of the partnership. Of course, the buyer may later on ask for the reformation or the changing or amendment po ng contract kasi po nakapangalan lang yun sa isa sa mga partner, and then the property is registered in the name of the partnership. So, since usual way naman yun, have the reformation to show the true intent of the parties. Ang reformation? Yan po yung atin pong remedy in case po ay hindi po nagtugma yung nagiging deed of conveyance po with the property na registration. So that now the seller's name would appear to be a company, provided of course the other partners would not object. So if the partners had not been engaged sa purchase or sale of land, the buyer would not even be entitled to the equitable interest kasi unauthorized na yon, hindi na yon usual way. So take note of that in relation to 1818. Let's now proceed with the third paragraph. Under the third paragraph, what if the title to real property is in the name of one or more but not all of the partners? What would happen if the property is in the name of one or more but not all of the partners? So here, under third paragraph, the partners in whose name the title stand or kung kanino ang property nakapangalan could convey the title to such property. Could convey or could transfer the property, the title to such property. So let's have an illustration. So what if A, B, C, and D were partners in a real estate firm? So real estate pa din, usual way natin, buying and selling of real properties, named E Company. Although a certain parcel of land really belonged to the firm, nakaregister lang siya in the name of A and B. A and B sold in their own name the land to X. May the firm get back the land? Well, the answer to that is since the firm is engaged in the real estate business, the act of selling the land was for carrying on the usual way of the firm's business. So the firm cannot get back the land for the title thereto has been conveyed to X. So malinaw naman sa paragraph 3 na that the partner in whose name the title stands could convey title to such property. And here, suppose daw in the preceding problem, nakapangalan siya alinman, di ba, kay A or kay B. Suppose in the preceding problem, A and B have not been expressly disauthorized or unauthorized by the firm to sell the land, would your answer be the same? So it depends. Kapag po, if X have acquired it in good faith and he has no knowledge na wala pong authority yung dalawang iyon, then the answer would be the same. So, na-acquire na kasi niya for value or in good faith yung properties. Hindi na po siya po pwedeng habulin. Ang pinaka-resort na lang ng partnership go after those partners who have acted, who have sold the land without the authority. So sorry for the clerical error again. So what if daw if it had been in bad faith yung atin pong buyer, then the firm could get back the land unless X, the buyer here in turn had sold the property to Y who is in good faith. Kumbaga, na-transfer na naman niya into a buyer in good faith. The assignee, which is Y, so the next transferee or the next purchaser of after X is a holder for value without knowledge. So, hindi na yun po pwedeng habulin po ng partnership. So, hope that is malinaw. Let's now go for paragraph 4. Under paragraph 4, what if the title to real property is in the name of one or more of all of the partners or in a third person in trust for the partnership. So, kumbaga, ay pinapahawakan lang dun sa mga partner na iyon, di kay third person, para in trust po sa partnership. So, take note ha, meron tayong nakikreate na dito na another relationship, ano? And the trust and the beneficiary. So, the trust to trustee, ano. So here, basically, dapat po ang conveyance po, the conveyance is executed, the conveyance could be executed by a partner in the partnership name or in his own name po, pwede po yun. So, as an example, A, B, C, and D were partners in the real estate firm of E company. A certain parcel of land was in the name of A, but it is in trust for the company. What if A sells the land to X in the name of E company? Will X become the owner? No, because po ay equitable interest lang. No, what would X get will only be the equitable interests of the firm kasi it's being held in trust, diba? So if A sells the land to X in his own name, will X be the owner? No pa din. Why? What X gets here is still only the equitable interest of the firm. It is clear because in both instances that under the registry records, A is only a trustee. So ang kanyang claim is only ang claim ni X here as a buyer is only the equitable na interests. So, because of, yun na nga, trustee lang po dito si A, regardless kung ang sale is in the name of the partnership or in the name of A, but still, it is only being held by A in trust for the partnership. And let's now go for paragraph 5. Under paragraph 5, it says that what if the title to the real property is in the name of all of the partners? Paano yung conveyance nun? Then, if that would be the case, lagi ko sinasabi sa inyo, lagi dapat tugma, real property yan. Kung kanino nakapangalan, let's say yung nakapangalan sa inyong mga magulang, you have nothing to give if you don't have it, di ba? Kung wala ka nun, if you have no right to it. You cannot impart what you do not have or you cannot give what you do not have. So, ibig sabihin, pag hindi yun iyo, wala kang karapatang pamigay, di ba? So here, title to real property is in the name of all the partners under paragraph 5. Then the conveyance document should be executed by all the partners in order that rights would pass into the transferee or dun sa purchaser or buyer. So as an example, A, B, C, and D were partners in the real estate firm of E company. A certain parcel of land was registered not in the name of the firm but to all of A, B, C, and D. If A, B, C, and D will sell the land to X, will X become the owner or will he have only equitable interest? So here, X will get the title to the property, consequently becomes the owner because the law says that where the title to real property is in the name of all the partners, ang conveyance executed by all the partners will basically pass all the rights in such property. That's under paragraph number 5. So hope that is very clear with us under 18 19. Where is my 1820? So under 1819, 1820, 1821, let's have first, what is this? You have it canceled. You're not working. Why? Why you're not working? So I think we're done with paragraph 5. This is all of Article 1819. Basically, 1820 although it's not being presented, ang 1820 sinasabi lang naman ay an admission or representation made by a partner concerning partnership affairs within the scope of his authority in accordance with this title is evidence against the partnership. Kasi by mutual agency tayo. Ano ba yung admission? Kapag po ang isang partner ay nagkaroon ng statement in which he admits that something is true or that he or she has done something wrong, then it could be an evidence as well against the partnership. So, yun po, if it concerns the partnership affair, then it would basically be an evidence against the partnership. So, an admission that he has done something within the scope of authority, then it basically an evidence against the partnership. Pero, kapag po ang admission na yon ay made by a former partner na nag-retire na naman after he has retired from the partnership, so basically, hindi na po yun nagbabind sa partnership at hindi na po yun pwedeng gamiting evidence against the partnership. So that, hope that is very clear. And let's proceed with 1821. Under 1821, notice to any partner or any matter relating to partnership affairs and the knowledge of the partner are acting in particular matter acquired while a partner or then present to his mind and the knowledge of any partner who reasonably could and should have communicated it to the acting partner operates as a notice to or knowledge of the partnership in case lang of fraud on the partnership committed or with the consent of that of the partner. So let's break this down. Basically, yung notice ba to a partner could be considered a notice to the partnership. So clearly, here, a third person, if you desire to give notice to a partnership or some matters pertaining to the partnership business, you need not communicate to all of the partners, ano? Kasi may mutual agency naman tayo, di ba? So, tandaan natin yun. It's based on trust and confidence, fiduciary relation. So, if there would be notice delivered to a partner that is already under this provision and effective communication to the partnership. What if situation? What if you have acquired knowledge or you have acquired notice or you have received a notice before you become a partner to the partnership? Does that constitute a notice to the partnership or basically um, after which a ano na-involve ka? Well, in that case, ignorant po yung atin pong ano, 'di ba? Because you have acquired that knowledge before you become a partner and you have acquired that not being a partner. So it could not be considered as notice to the partnership. Take note of that. So let's now proceed with 18. Ano ba yung mga instances pala where knowledge of a partner is considered to be knowledge of the partnership? Opo, mamaya po. Uh-huh. One is under this provision, yung pong knowledge of the partner acting in the particular matter acquired while being a partner, di ba? One. Second, knowledge of the partner acting in the particular matter then present to his mind. And third one is knowledge of any of the partner who reasonably could and should have communicated it to the acting partner. So the only exception na masasabi natin wala pong knowledge and would not be basically bind the partnership and would not give notice to the partnership is that if in case of fraud on the partnership committed by or with the consent of that partner. Adding 1821 ha, it does not mean that or it does state basically that there is no need to implead a partner or papangalanan ng partner in order to be bound by the partnership liability. So, basta in any matter lang, notice to any partner of any matter relating to the partnership affairs and the knowledge of the partner acting in so particular matter, but particular matter act operates as a knowledge to the partnership. So take note of that. So it does not provide relief under 1821 is that it does not provide relief for a reverse situation as well. Just take note. Or yung sinasabing notice to the partnership doesn't necessarily a notice to the partner. Just be wary of that. Ano, it doesn't provide for a reverse na situation. And let's now go for 1822. What if there is a wrongful act or omission of a partner? So under 1822, it says that whereby any wrongful act or omission of any partner acting in the ordinary course of business or usual way of the business of the partnership, o di kaya man may authority of the co-partners, loss or injury is caused to any person not being a partner in the partnership, or any penalty is incurred, the partnership would be liable. Therefore, to the same extent as the partner so acting or omitting to act. Take note under 1822, usual way kasi yung the partner is he committed the wrongful act or the omission while doing the usual way of business of the partnership at the same time I authorized by the other co-partner. So basically it will bind the partnership. So the partnership would be liable. As an example, A, B, and C were partners while acting within the scope of the firm's business. A committed a tort or yeah, let's say an accident to a third person against X. Is the firm or the company liable? Yes, under 1822. A, B, and C, as well as the firm itself, are liable. Ito yung isa na din sa mga solidary liabilities ano, na sinasabi natin kanina as against with a joint na liability under third persons 18 ano ba yun 1818 ano. So note that even innocent partners are civilly personally liable without prejudice of course to the right to recover against that guilty na partner. So that is 18 1822. So the law under 1822 speaks of an injury to any person not being a partner. Thus, Article 1822 apply to injury to an employee, not a partner of the firm. So the answer to that is yes, because a mere employee is not necessarily a partner. And in one case, Utah case, the court decided otherwise apparently because the injury should have been caused to a person not connected in any way to the firm. So hindi siya naman daw partner. And here it basically mentions again yun pong when do the firm and other partners are not liable. So if the wrongful act was not done within the scope of the authority and for the benefit or with the authority of the co-partners, if the act or omission is not wrongful, and then if the act or omission, although wrongful, did not make the partner concerned liable himself, so civilly liable. So if the wrongful act or omission was committed after the firm has been dissolved or has stopped business, and was not in connection with the process of winding up, then the firm would not be liable and other partners would not be liable. And here, yung solidary liability natin, as what I've mentioned, di ba kanina, yung po mga exceptional circumstances making the partnership liable. So here, While in torts and crimes, the liability of the partners is solidary. In contractual obligations, yung pong may kontrata po tayo, is generally merely na joint. Take note of that, So sa torts tsaka sa crimes po, solidary liability yung other partners. Liable din sila. And then, pero kung contractual obligations under 1816 pala, generally joint lang. While Article 1816 of pro rata liability of the partners, and while the Code of Commerce says that the pro rata in this article means in proportion to their contribution, still the Supreme Court has ruled that pro rata here means joint lang po ang obligation under 1816. Ito'y settled na natin. Huwag na malito. Huwag na malito. And note that torts and crimes result from individual acts of the partners, while contractual liabilities arise from the partnership obligation. This one pertains to obligations of third persons based on contracts, diba? Pag torts and crimes, yung tipong naka-figure ng accident, yung one of the partners while delivering. Basically, ay liable ang partnership, solidarily, And here, note that it is not only the partners that are liable in solidarity, it is also the partnership. And for the last part, just an example before we're gonna go for an entry of a new partner. For the last part, this is as an example lang, let's have A and B are partners. A, this is already under 1823. A and B are partners. A misappropriates. In case of misappropriation, ano po ang liability? A and B, ano ba yung misappropriation? Nakadispal ko? Or na use the money of the partnership basically for your own personal na interest. So A and B are partners. A misappropriates a sum of money belonging to a customer. Let's stop there, please, first.